forward in light of what I've already expressed with regard to my concern with the disqualification motion and related confidential and privileged information. And generally my understanding that perhaps what the idea here is, and it seems to be a good one, that we begin the temporary injunction hearing to a degree that if it's recessed, we can then move forward with a restraining order in place. I think that's the gist of what I've heard in a lot of quick conversations after the conference. I might submit to the court, because I'm not exactly sure how to address some of the issues that Mr. Jeffrey raised with regard to what I believe to be confidential and privileged information in my opening. With regard to the injunction issues, there's been a lot of back and forth. I think the majority of what we've talked about here this morning has been on special appearance jurisdiction issues. But there were some things addressed that I would need to address on the injunction. What I might submit to the court is that Ms. Rathbun has submitted an affidavit in support of the temporary restraining order in the original petition that is offered, I think, in support of the injunctive relief. We would agree to the entry of that affidavit as the testimony required at this particular point in order to ripen the hearing, if you will, so that we can move forward. I don't have to open any further, nor do we have to hear from Ms. Rathbun any potential confidential information, nor do we have to cross her on it somehow.
I appreciate the offer. I'm not sure that I can dictate that necessarily, or that everybody would have to agree. My point is that I did restrict Mr. Jeffries in the offer of any testimony to current matters. So we're not going back to 2004 or anything of the sort today at all. I'm not sure I can force him to agree to submitting that affidavit as his evidence.
Okay. I don't want to address the council per se, but
Your Honor,
ask him if that's
if I may help, there's two parts to this
I'm
case.
okay with it personally if that's the way we want to go.
There's two parts to this case. There's the Texas part that we've sued for, and then there's our burden, as you've already heard, they claim we can't do it, of showing who's responsible for all this stuff. That's the part they have concerns about. Who's responsible for it behind the scenes? Mrs. Rathbun's testimony will not touch on that, but it will have plenty of relevant evidence for the court to consider that she actually knows about that happened here in Texas. So we're not getting into that stuff. And no, we don't agree to use her affidavit. Generally speaking, affidavits are not competent evidence in an injunction hearing, and we don't agree.
But I mean, outside of agreement to the contrary.
right. And my proposal would be to submit the affidavit to ripen this hearing so that it can be recessed for the injunction of temporary restraining suspension. I wouldn't be asking that he would not, in addition to the affidavit submitted, be able to put Ms. Rathbun on for full direct examination when we reconvene. That would be part of my thought process.
Yeah, part of the delay between the last time we consulted in the chambers and me getting to the bench was just simply trying to look at the calendar, and the calendar is difficult. I'm probably going to be willing to receive a certain amount of testimony, but I do want it ultimately to be restricted to the issues at hand regarding the alleged injury, the harm, and why it's susceptible of injunctive relief. So, and all the other issues, to the extent it ultimately is dealt with, that will be at a later time.
Okay, thank you.
Yes.
Just very quickly again, for the court reporter, I'm Les Strieber with David Mendoza. I represent CSI. And I'm going to try and kind of weave through what I've objected about, and then Mr. Jefferson covered some of the waterfront, also in general background about the church and things like that. So I'll try to be as brief as I can. when I was here, I guess it was a couple of weeks ago, one of the things and one of the difficulties I was having is I had just been retained. My firm had just been retained. And I've spent the past couple of weeks kind of trying to get my mind around an understanding of the Church of Scientology and its religion. And the reason I'm going here is because it's extremely important to have that understanding. And as I've gained that knowledge about the church, it's helped me understand the request for injunctive relief and the rights of both parties in this proceeding. I won't go into it any further. Mr. Jefferson did a good job, but the Church of Scientology is it's an established religion. Talk about recognition before the United States Internal Revenue Service and the law, but from a more practical standpoint, it's a very well established religion, and it's based upon the writings and teaching of L. Ron Hubbard. And I don't know if the court is familiar with Mr. Hubbard or his writing. Kind of the preeminent writing is the book called Dianetics, and it sets out a lot of his teachings and a lot of his thoughts that are the basis for the Scientology religion. It currently has churches in 150 different nations, and it both produces written literature, and it's like everybody else, it's available online. I think here 19 million people have visited their website. So it's all over the world, it's all over the United States, it's all 50 states, and countries from Italy to Russia to everywhere else. I think Mr. Jeffrey said something about that this is not a religious dispute, but Judge, at its heart, it is. The plaintiff, Monique Rathbun, is the wife of Marty Rathbun. And as Mr. Jeffrey said, he was with the church for about 20 years, and he had a very high office within the church. There were circumstances in which he was asked to leave the church, and that was about 10 years ago. As Ms. Rathbun states in her affidavit, and this is very important for injunctive issues and directly with respect to the issue of whether or not there's been any harm. In her affidavit, paragraph number 4, she states, "We have been now living under this constant surveillance for 4 years." Jumping over some statute of limitations issues, which will be in the merits, with respect to the imminent harm, we will be asking the court to consider the admission in her affidavit that they've been aware of the surveillance for 4 years. You're also going to hear evidence that they contemplated, hired, and drafted lawsuits with respect to this activity over 2 years ago, and that was never filed. And so, on the issue of imminent harm, going directly to one of the issues related to injunctive relief, it's important. As Mr. Jeffrey said a few minutes ago, Mr. Rathbun left the church, and for 4 or 5 years, there's nothing. There was no controversy. There was no dispute between the parties. And as she states in her affidavit, she says in 2000, paragraph 3 of her affidavit, "In 2009, my husband broke his silence about Scientology. He gave national media interviews." She says, "I've never been a Scientologist. I gave no interviews, nor did I speak publicly about these matters." But the point is, all of a sudden, after about 5 years of leaving the church, he started speaking out. And I'll skip the theatrics, but one of the ways that he spoke out is he started a blog. And I could ask somebody to put it up. I'm not. There's like 25 large 3-ring binders of all of Mr. Rathbun's writing on his blog, all of which are acidic, hate-filled criticisms of the Church of Scientology. It's daily. It's constant. Mr. Rathbun has been on Anderson, Cooper. You name a network, he's given an interview. You name a major national magazine, he's been given an interview. He's quoted throughout the television media in the United States, in Europe. He's quoted in all of the national magazines, local newspapers, San Antonio Express News, Florida newspapers, blogs. And Judge, there's blogs out there that are sole purpose is hatred towards the Church of Scientology. So I'm going to go back to tell you that this is a religious dispute. There are blogs against the Catholic Church. There are blogs against the Methodist Church. There's blogs in anything involving religion, because aside from politics and homeowners associations, there's always going to be somebody that is going to be defiant. There's going to be somebody with a personality that becomes obsessive and begins a crusade against whether it's a homeowners association, the Methodist Church of Bernie, where I'm from, or the Catholic Church in downtown San Antonio. And a really important issue in this case is the orthodoxy of religion. Methodists have an orthodoxy. The Catholic Church has an orthodoxy. Scientology, the Church of Scientology, has an orthodoxy. And it is, there's scriptures. It's what is their religion. And Lamont can't go out and start a Catholic church that says Lamont Jefferson's Catholic Church, put a great big sign that says Lamont's Catholic Church. I can't do the same thing for a Methodist church. Not without a visit from somebody in the Catholic Church or the Methodist Church. An organized, established religion has the right to preserve its orthodoxy. It's the consistency. Their members, their congregation requires that consistency. And occasionally, all religions have a heretic that goes out and tries to change the orthodoxy, doesn't respect the orthodoxy. And there's nothing wrong with attempting to hold that orthodoxy, hold the scriptures to what they are intended to be and what the church has established them to be. This lawsuit, while it's in the name of Monique Rathbun, is a dispute between Marty Rathbun and the Church of Scientology. That's what this fight is, and it's over the orthodoxy of Scientology. Mr. Rathbun, through his blogs and through his own teaching, and by the way, his own business in which he's practicing some of the activities of Scientology. You're not going to hear Mr. Rathbun or Ms. Rathbun say, I disagree with Scientology. They're going to say, I disagree with the way CSI, my client, is holding its orthodoxy. That's the fight here. Now, I've coined my own little phrase called the Rathbun Cabal. There's a group out there in the United States that have teamed up with Mr. Rathbun. You're going to hear, I believe, testifying a man named Mike Render. You're obviously going to also hear from Monique Rathbun. The three of them and others are directly or indirectly involved in 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 different legal proceedings against the Church of Scientology. They're involved in litigation in Los Angeles, Southern District of Texas, Middle District of Florida, 6th Judicial District in Florida, San Patricio County, Bexar County, Moore, California, 15 different pieces of litigation. It's become an industry for it. And here we are in one more. And every one of them is a call to the media. Every one of them is played to the media. In this particular case, the next day after the lawsuit was filed, the media is called. How does the media pick up on a lawsuit filed in, how does the media in St. Petersburg, Florida, pick up on a lawsuit filed in Comal County?
Excuse me, I need to make an objection. Your Honor, I make very few objections, but they jumped all over me for arguing the case. Are they presenting evidence of any of this? This is just pure argument that won't even be in the record. I think he's going very far afield, and it's just plain false.
There's an issue of I'm sorry, Judge.
I mean, let's do try to stick, because we are here on a temporary injunction hearing for preserving the status quo if certain elements can be met. So I mean, that's regardless of who shows up for an open court. I understand what you're saying.
I appreciate it.
I'd really just like to keep the opening statements directed to that, just as a argued to Mr. Jeffries as well.
Thank you. The second most important, maybe not even that order, element to a temporary injunction hearing is going to be their probability of prevailing on the causes of action that they have alleged. The essence of their causes of action is they do not like the surveillance that has occurred by the Church of Scientology on the Rathbun. It's important to understand that when there's a church with their orthodoxy that's being attacked, changed, modified, that they need to do something about it to preserve their own religion for the benefit of their membership and the benefit of the church. And so I'm bringing out what it is that Mr. and with the assistance of Ms. Rathbun have done is place themselves through the media, through daily, if not hourly blog activity, that place themselves in positions of public figures. And with respect to First Amendment rights, with respect to a company's or a church's ability to defend itself legally, 15 lawsuits, participation in lawsuits, consulting in different lawsuits, they have an ability to defend themselves and understand what it is that's being challenged in their orthodoxy and in their church. And so they're going to be asking the court to fashion some sort of equitable injunctive remedy that, let's just take this lawsuit, for example, they've been sued. They should have the ability to do what every defendant, what every company is entitled to do legally within the bounds of the law, within the bounds of the Constitution, to defend themselves, to understand both in terms of the orthodoxy of the church and the allegations that are going to be brought or are being brought against them. Another important fact, and I need to kind of walk the tightrope on this. Mr. Rathbun, while he was with the church, was in charge of, or I should say in charge of, worked with legal counsel and worked with other members of the Church of Scientology related to the trademarks of the church. The Catholic Church has trademarks. Methodist Church, Presbyterians, all religions have trademarks. And it's important for them to preserve those trademarks. We will submit, and evidence will show that Mr. Rathbun has continuously, since out of nowhere, he starts his fight with the church when he stops his silence, he starts violating those trademarks. Trademark litigation is difficult. There's always, or a patent infringement, any intellectual property, it's very difficult sometimes to understand how your trademark is being violated. You can walk up to somebody, you can write a letter, you can ask for a meeting, they deny that they're violating it, and so you need to do certain things to protect your trademark. And so that's a context that needs to be understood with regard to the issue of probability of prevailing. It's our position, and the evidence will show in a temporary injunction hearing, that anything and everything that the Church of Scientology did to protect its trademark, to protect its orthodoxy, they did so within the law. They did not violate the law. They did not violate Ms. Rathbun's privacy. They did not violate the privacy of a public figure who has no legal expectation of privacy. And it's going to be our position at the temporary injunction hearing that because what we were doing was legal and within our constitutional right to protect our property and our members, that there's nothing that this court can do to enjoin any of the activities that they themselves are going to prove that we were doing. They're not going to prove that anything was illegal, that anything was improper, that anything was outside the bounds of the law, that an investigator can do, that anybody needs to do to protect, legally protect their property. I'll add one thing that I skipped over. In addition to his blog, you can get on his blog. He has a video.
Your Honor, Mr. Rathbun is not a party to this case. His entire opening statement is about Mr. Rathbun. This is Monique Rathbun's case.
I understand. Totally mistaken.
On the blog that is with the assistance of Ms. Rathbun, Ms. Rathbun assists him in the administering of his blog. On his blog, there's videos that they post. There will probably be videos from today posted. There's videos by Mr. Rathbun in which he calls out to all Scientologists, all members of the Church of Scientology, to bring him, in essence, to convert or steal property within the church. And at least on one occasion that we are aware of, a church member did in fact take computer hard drives in Los Angeles, California, and met Mr. and Mrs. Rathbun with that property. And it's important in addition to protecting the orthodoxy of the church, being able to defend itself in the variety of legal matters that they've embroiled themselves in outside of this lawsuit, to defend in this lawsuit, and to protect its confidential properties that he, on YouTube and on his blog, are advertising and soliciting people to steal and bring to him and he'll protect. And so it's abundantly necessary that the church be allowed to defend itself, and any request for injunctive relief, those specific issues are going to need to be addressed and looked at with regard to any injunctive relief that would prevent them from being able to do so. Thank you, Jim.
Okay.
Your Honor, if it's appropriate, I'm going to reserve my opening statement until defendant's case.